Thank you very much, and welcome to the Committee on Procedures. Members, let me just get back to the start. So today, members, we're having a briefing today from the Head of Legal Services to talk to us today about the role of the Assembly Legal Services team. Ray and Research Officer will attend to outline the role of the Assembly Research and Information Services and to present his research paper on issues under consideration by the Procedures Committee and other legislators. The committee will also consider arrangements for the strategic planning session, which, as we know, is planned for Wednesday the 10th of April, and our meeting is open to the public. Members, this meeting will be recorded and broadcast throughout Parliament buildings and online. Members, you're welcome to use your mobile devices as long as they're in airplane mode and all devices are muted. As always, it's not permitted to take photographs or record any of the meeting. Members, just to ask those present in the room if anyone has any interest to declare in relation to today's meeting. And I know we have some members that I'm just about to talk about who are online. If they have any issues that they would wish to declare, then if you want to bring that forward. And just as he's walked into the room, not to embarrass him, members, as you know, we were having a change in membership, and I'd like to welcome Robbie Butler to his first meeting of the Committee for Procedures. Welcome, Robbie. So, members, moving swiftly on, members, I'm aware of any other apologies today. I do have one apology that was provided to us, and that's the Deputy Chairperson, Sinead Ennis. And online, we are being joined today by Trevor Clark. And I know that Matthew O'Toole had made a request to come in online, but I don't... Is that Matthew in now?
No, that's Trevor.
That's Trevor's in now. Matthew had made a request to come in online today, so we'll note whenever he joins the committee this morning. But is there any other apologies today? Okay, thank you very much, members. So moving on then to agenda item 2, the draft minutes. Members, the minutes of the previous committee meeting is pages 5 to 11 of the meeting pack. Members, you've had time to have a review of those. Are you content that the minutes are a true reflection on the proceeding of the meeting held on the 28th of February 2024? Content? Yeah, thank you, Malaysia. If so, that's okay, then I shall sign the minutes. Thank you very much. And then moving now on to agenda item number 3, matters arising, which is committee membership. The list of the membership of the committee has been provided at page 13 of your meeting pack for information. We may have another update to the committee just moving forward, because I'm aware that Gary Middleton has a clash with this committee, and we're waiting on the DUP just confirming if there's any changes on that. But we'll hear, I'm sure, of that shortly. Agenda item 4 then, the role of Assembly Legal Services. Today, Jonathan McMillan, Head of Assembly Legal Services, is attending to outline us on the role of legal services and the support it can provide to the committee, particularly in relation to the amendments to standing orders. A copy of Jonathan's PowerPoint presentation can be found from pages 3 to 6 of the tabled pack that we have all received. Jonathan, you're very, very welcome to the meeting. Thank you very much. We'll go through your presentation if that's okay, and then if you have any questions, we'll hold those to the end, and you have an opportunity then to speak to Jonathan. Thank you very much, Jonathan.
Thank you, Madam Chair. I should say, while I have an Assembly laptop, it is significantly older than this refurbished room, so I don't have a connection, and I'm going to have to ask Michael to move the slides on at various points, but other than that, it should be reasonably straightforward. So what I propose to do is explain very briefly the directorate structure. I know Ray's here to talk about Ray's, so I won't dwell on that in any detail, but I'm sure a lot of members have already had dealings with human resources, finance, parliamentary services. The Directorate of Legal Governance and Research Services, and if I go to the first slide, is a little bit sort of more of a background body. We're providing a lot of support behind the scenes. Can I have the next slide, please? Thank you. So you'll see there the various business areas that sit within the Directorate. I put Legal Services Office first. but actually raises the biggest one. So legal services and information standards, I manage both of those because there's quite a lot of legal input into the work of those business areas. Then there's RAISE, the Examiner of Statutory Rules, whom I understand many of you will already have met in the course of getting our delegations through committees, the Procurement Office and Governance Services. So that's who we are, and then I'll now describe briefly what we do. So if I go to the next slide, please. So this is the legal services team. I head it. There are 8.5 full-time equivalent lawyers working in it. 2 of those posts are vacant, I should say. We are all practicing barristers and solicitors. Our role is to provide advice on all legislative, procedural and corporate matters, and to take and defend legal advice, take and defend legal actions on behalf of the Assembly. So I realise that the principal focus of this committee is likely to be on the legislative element of the legal services role. So I'll just talk a little bit about that. If I could have the next slide. Thank you. So the principal role, and I guess many of you may have had conversations with me in respect of this, is advice on the legislative competence of the Assembly. So the Northern Ireland Act 1998, which confers powers on the Assembly, also limits its legislative competence. Within the limitations of its legislative competence, of course, the Assembly has very broad powers. So we would provide advice to the Speaker on bills proposed for introduction under Section 10 of the Northern Ireland Act. We'll also provide advice to colleagues as members develop PMBs and matters that go directly to legislative competence. And occasionally we will be called to speak to committees if sometimes a third sector body will raise a question as to legislative competence, though that's less common. The other key function of legal services, I guess, is interpretation of all forms of primary and secondary legislation, the 1998 Act, EU law, or as I suppose I should now call it, assimilated or retained law, and human rights legislation. And that's a service that we provide to all committees. I should say we don't advise individual members, but we will advise members as part of a committee. And if you do have an issue, speak to the clerk or whomever, and no doubt we can find a way to assist you. But that can be important if, say, a department is bringing forward a bill which is being considered by a committee, and the committee has concerns of the effect of a particular provision. It's important that the Assembly has access to an independent legal resource. And as some of you may know, all of the parliaments in the UK and the Houses of the Erectus in Ireland have independent in-house legal teams because it's seen as fundamental that the legislature has a source of access to legal information outside that provided by government or indeed but by other parties who may have interests of their own. So that's a key role, and we will give independent advice to committees on any matter essentially that they ask us about. The third point you will see is obviously particularly pertinent to today's audience. That's legal advice in respect of the drafting, interpretation and application of standing orders. So the role of this committee, which I will come to in just a moment, is basically devising policy changes for standing orders, and we help the committee to give effect to those policy changes. The other aspects of our role, which I won't focus on in any detail, legal advice on matters relating to plenary and other procedural matters. So obviously that's principle for parliamentary services, but if a question arises around various or administrative discretion, we'll assist our colleagues with those. And then finally at the bottom, legal advice on amendments to bills and powers of compulsion. So members may be aware committees have certain powers of compulsion under the 1998 Act. That takes place within a fairly structured legal framework, and we can advise on those as is required. So that's an overview of what legal services does, and what I would propose to do now is go through briefly elements particularly relevant to this committee on standing orders. So the Northern Ireland Act obviously creates provision for standing orders. I'm going to talk about the difference between mandatory and discretionary provisions. I'm going to ask the committee to consider sort of general principles affecting the changes to standing orders, explain the process of amendment, and give you an example. I'll mention some recent legislative changes which are likely to be relevant to the committee at the end, and then I'll take questions. That probably won't take as long as you think it will. So if I could take the next slide, please. So this is the function of the committee. I think it's Standing Order 52. You are to review on an ongoing basis standing orders and procedures of the Assembly. Now, obviously, there have been various periods of hiatus in which the Assembly has not been meeting. There has been legislative change in that period, and things have moved on generally. And I know that both of the clerks to the committee have been using some of that time to consider areas of standing orders which might benefit from reform. So that is obviously something that the committee is likely to consider going forward. The statutory basis for standing orders, if I can move to the next slide, is Section 41 of the Northern Ireland Act 1998. And again, this is the kind of provision which is fairly common to devolved legislatures. The Enabling Act will make provision for standing orders. It'll set out some stuff which must be contained in standing orders, but otherwise the extent to which proceedings are regulated by standing orders is a matter for the Assembly, but in the initial stages, obviously, for this committee. You'll see there standing orders are not to be made, amended or repealed without cross-community support, which can be significant. And then Schedule 6 of the Northern Ireland Act makes further provision. I'm not going to talk about Schedule 6 in any particular detail, but I am going to talk about the difference between mandatory and discretionary provisions of standing orders. So if I go to the next slide, please, Michael. So I had already mentioned Section 10 of the Northern Ireland Act on legislative competence. So this is an example of a mandatory provision. Standing orders shall ensure that a bill is not introduced if any provision would be outside legislative competence. And if you look at our standing orders, Standing Order 30 makes that provision. That must be included in standing orders, so we don't really have an option about that. And then you will see what I think is quite instructive. The next box is Section 13 of the 1998 Act, which talks about bills. So those are the mandatory provisions that the Act says we must have as regards bills. A general debate on the bill, a consideration stage and a final stage. You'll notice there's no reference there to committee stage or further consideration stage or exceptional further consideration stage. As long as we have those three minima, so we need a final stage, consideration stage, general stage, we can supplement that. And we have done it. I think, we have possibly 7 or if you have an exceptional stage, perhaps 8 stages of a bill. In Scotland, they only have 3. So those are matters that are, but the way in which their bills proceed is different. So those are matters that the Assembly has decided for itself within the structure created by the 1998 Act. And then, if I move on to the next slide, please, the discretionary provisions of standing orders are things which, the Act says, well, you can supplement this if you wish, but it doesn't require us to do so. So the examples I've given there are at Section 16C, that's as regards nominations of ministers, FM and DFM. There's already some stuff which must be included around time periods and so forth, but in theory we could supplement that. You'll see that we can include provision as to participation of the presiding officer deputies. In fact, we have done that and limited the extent to which they can vote in proceedings. And then there's a power in the third box, and that's the power that enables us essentially to exclude members of the public from proceedings if that's necessary, although there is a presumption that all proceedings are in public. So if I go to the next slide, I just want to set out what that framework means. So standing orders can be used only to regulate proceedings of the Assembly. You can't use them to confer powers or duties outside the Assembly, so you couldn't do in standing orders the sort of thing you could do in a bill, but you can create conditions for example, ministers wanting to bring legislation to the Assembly or private members wanting to bring forward legislation, because that does relate to proceedings in the Assembly. So you can say we're only going to let your bill through if you do X and Y. That's an obvious example. Standing orders can't make any provision inconsistent with the 1998 Act. That's a fairly basic legal principle. Because the 1998 Act is what gives us the power to make standing orders, we can only make provision which is consistent with the 1998 Act. The third issue is also relevant. They are essentially a form of subordinate legislation because they are made under a piece of primary legislation. They're pretty unique, though, because they're really only of relevance to the people that work in this building and the members that do their business in this building. But they can be subject to judicial review on standard public law grounds in the same way as any other piece of legislation. So that's something we consider, when we're considering amendments to standing orders. But again, I would expect the court to be reluctant to interfere in the internal proceedings of a legislature unless we've done something outrageous. And we're here to help you not do that. Anyway, I'm just going to talk very briefly about the process for amendment to standing orders. So if I go to the next slide. This slide is fairly self-explanatory. As I mentioned, changes to standing orders require cross-community support. They're amended by motion. This committee develops proposals reflecting its policy preferences. I assume those are in respect either of matters drawn to its attention particularly or matters are identified by the committee itself. The clerk to the committee, or the clerks I should say, will then provide instructions to legal services on the policy, and we'll draft amendments to give effect to that policy. Now, I very much shortened that. That will be an iterative process. You'll probably be looking at 2 or 3 drafts. We'll be coming back and saying, well, is this precisely what you want? And you'll be saying, no, can you change that to say X and Y? And that's a perfectly standard process, and that's something we're familiar with doing. And then, when agreed by the committee, as I say, after that process, the amendments are placed in the order paper and voted for in the Assembly and plenary. They get cross-committee support. That amends our standing orders, and those are the basis of how the proceedings of the Assembly are regulated going forward. So I've given just an example of amendments to standing orders which we brought in during COVID. These were the temporary provisions. They're on the next slide. I've only given, I think there are about 20 of them, so these are just the 2 initial ones. This is what you will see when a legal advisor brings a proposal for a legislative change to standing orders to the committee. So you'll get this table, which will set out in the left-hand column the proposed draft, and will set out in the right-hand column the effect of that. So basically, if you like, that's kind of the EFM for your standing order. This is the standing order. This is what it does and why. And you'll see there we've just talked about the particular effect of that standing order. And then also what will accompany that, and it may look slightly different depending on whether you're completely replacing standing orders or just amending a standing order, will be a motion, will be draft text to form a motion. And if I could have the next slide, when those standing orders were agreed to the committee, they go on as committee business and they look like that. And that's what the Assembly votes on. And then our colleagues will go away and make those amendments. So that's the process. I'll just pause there. If anybody has any questions about that process, I'm happy to answer them.
Yeah, can
yes,
I
by all means.
Jonathan, earlier on in slide 9, when you were talking about the processes, for taking forward a new standing order or a change to a standing order. So there's debate, consideration and final stage. Does that all happen concurrently, or does that mean that there's a split?
Those are the stages of an Assembly bill.
Okay, yes.
So I was just giving that as an example of something which must be included in standing orders, but actually standing orders are changed by resolution. Okay. Now, it needs cross-committee support, but it's a resolution. That's
what I was just checking then, yeah. that if we bring forward, as we see here in the sample order paper, so if we've brought forward amendments that have been agreed by this committee, and to be honest, we're all parties here, so I hope we get support, but if we bring forward amendments, there is no further stage then for any other member to bring forward other amendments to our amendments.
I think I'd have to consider that, but I think in theory motions are amendable. I'm not sure if there's a particular rule around motions on amendments to standing orders.
Yes, it is a motion.
So, but I wouldn't give a definitive answer to that.
We need to be aware of if there's, because with the legal background and the amount of work that'll have to be done for the amendments that we should be taking forward, if a member brings forward an amendment to the motion, then
yeah, I confess I can't recall having seen an amendment to this, and it should also be said that motions to amend standing orders are frequently quite lengthy. It's not a 3 or 4 line thing. There are pages, of various changes, take out and insert this and that. So it looks really quite like a piece of legislation on the order paper. And amendments to that, in my experience, uncommon. I wouldn't rule them out, but I need to discuss that with the business office to see if they are admissible. But I can write to the clerks on that. Okay. The other thing I thought members might be interested in is the legislation which has come in since the Assembly was last delivering sort of its substantive business. So if I could maybe see the next slide. Sorry, Michael, could I have the next slide?
Broadcasting are doing it. There we go.
Oh, sorry, broadcasting, okay. I'm sorry, apologies to Michael. So I've mentioned Windsor Framework regulations here. They're quite interesting because the Assembly was down at the time, certainly the second set of regulations.
Jonathan, before you move on to that, my apologies.
Sorry.
Alicia had indicated there
Mr.
for a
McHugh.
question.
Move on to that. Thank you for your presentation. And it seemed to nearly sort of contradict what I was actually thinking in my own head whenever you presented the occasion when changes were made to standing orders in terms of proxy voting. Yeah. But I'm sure that was as a result, say, of COVID and so on.
It was a result of COVID, yeah.
And what's the likelihood, or has there been many incidents when standing orders or the current framework has been actively modified or changed over this last number of years?
I'm just looking at my copy of standing orders, Mr. McHugh, and I see 1, 2, 3, 4 pages setting out changes to standing orders which have been made since 2008. So they do change quite frequently. They change both as legislative requirements imposed on the Assembly by the 1998 Act change, but also as the Assembly decides to change its procedures in particular ways. So, for example, the introduction of an opposition, that required a fair few changes to standing orders. Provision for urgent oral questions, provision for member statements. Yeah, the members are obviously more aware of these things than I am, so I won't say any more on that. But there has been a significant evolution of standing orders. I mean, if you look at the initial standing orders of the Assembly, they're probably about half the size that these are, and if a large there's maybe 30 temporary standing orders for COVID. There's provision for hybrid bills. All of that has come in the time I've been in legal services. So it does change. Yeah.
Hey, Jonathan.
Mr. Nolan.
Hybrid bills.
Hybrid bills. Yeah. I mean, I'm not going to get into this, but there's a thing. There are two classes of legislation, which is public legislation and private legislation. So public legislation affects everybody. Mm-hmm. They're like, changes to the criminal justice system, changes to, environmental regulations, all of that. Private bills are very much less common. They're like a railway wants to build and enclose a particular area of land, and that's only going to affect the people who have immediate interests in that land. It doesn't affect on the public at large. There are some bills that have effect both on private interests and on public interests, and those are called hybrid bills. Now, I only recall seeing one hybrid bill in 15 years. They're more common in Westminster. For example, I'm sure you've all heard of HS2. That was a massive hybrid bill. But they're very much less common here because we don't tend to have the sort of large undertakings that would be capable of bringing forward private legislation. It's not something I would say to members that should particularly interrupt their sleep.
Thank you.
And can I just double check, just so I don't miss Trevor, who's online, or Matthew, if he's there, if they have any questions?
Matthew's not in yet.
Okay, no, sorry, Jonathan.
Trevor, do you want a question? He's on mute.
No, I think we'll move on then.
Okay.
Sorry, Jonathan.
So this is my very penultimate slide. You'll be pleased to know. So I just thought I'd mention these as of potential interest to the committee. The Windsor Framework regulations and the Democratic Scrutiny regulations are quite interesting because the kind of procedures that one would routinely have seen in standing orders are actually now in the Northern Ireland Act. So the Schedule 6A and 6B of the Act have been brought in by those two sets of Windsor Framework regulations, and there's a specific provision in there saying standing orders can't make any provision inconsistent with this, and if it does, these regulations are to be applied instead. So that's quite unusual, but I think that's more a product of the Assembly not being sitting at the material time. I think had we been sitting, we'd probably have seen provision saying standing orders shall make provision A, B and C. The one that I think is probably going to be of the most immediate concern to the committee is the Minister's Elections and Petitions of Concern Act 2022, because that, as members I'm sure are aware, changed the structure for petitions of concern in section 43 of the Northern Ireland Act. Our standing orders have not been changed, so our standing orders relating to petitions of concern are now inconsistent with the Act. Now, we can get round that simply by applying the Act rather than the standing order, but I'm sure the Committee on Procedures would consider it desirable that those align. And then there's the Identity and Language Act. So again, that's an act which amended the Northern Ireland Act. That's principally relevant to the Commission and not to the Assembly. But again, members might want to consider whether there's anything in there that they might wish to reflect in standing orders. So that's all that I have to say. There is a final slide, but it's just a question mark. So if anybody has any questions.
Robbie.
Thank you, Jonathan. I know you've got the Windsor framework regulations there, but the most potent part probably to be tested is the storm break. So obviously it's built in some ways to mirror the petition of concern. I think that's obviously where they've got their grab from. In terms of that, so has legal service. So I know in terms of the briefings that we have received, there are some issues to be ironed out. There's a difference of opinion between the NIO and the description that we've been given and the analysis internally as legal services.
Well, I think I'd want to be a little bit wary about that, Mr. Butler, because we're obviously in open session. So legal advice is normally given in closed session. But I mean, I know we have advised the Windsor Framework Democratic Scrutiny Committee, and I'd be happy to pick up any issues that you think arise from that in due course. But I mean, as to the interpretation of legislation, you know, you can have 3 lawyers and 4 opinions, as I'm sure you know.
Pesky lawyers and legal.
Pesky lawyers.
Okay, thank you.
Jonathan, if I could just clarify, so we haven't had our away day yet to set our priorities. I imagine, or I'm thinking that it's just you have outlined when you talked about the Northern Ireland Ministers' Elections and Petition of Concern Act. There are some that would be something that needs to be done sooner rather than later, other and more immediate. Other items that will be more mid-term that we can maybe get to within this term of office, and then there'll be ones that are longer term things. So when we go away to have a look at those, I'm just actually thinking from our point of view, at the stage that we are now, we're not yet at Easter, but we are very aware that the summer recess is coming up. So if some of those, say for instance, something like the Northern Ireland Ministers' Elections Petition of Concern, after we have our away day on the 10th of April, if we decided that we wanted to take forward the standing orders for that, you've talked about you would draft and bring this to the committee for us to look at. But as far as drafting is concerned, obviously we'll take information on that and then ask you guys to do the drafting. How long does that take, just to give members an idea of the timescales on this?
It varies, okay, depending on the complexity of the issue and indeed demand. I mean, I think we developed the temporary provisions for COVID within like a week or less. But I would not encourage that. It was a nightmarish process. But I would say you probably wish to allow 4 weeks for a draft. And bearing in mind, rarely do any of my lawyers produce a draft which the committee is entirely happy with on the very first occasion. So, you know, you might need another few weeks after that to deal with sort of.
We meet every other week, so
yeah.
We'll need to.
Okay, well that would probably work quite well.
Yeah.
Yeah.
It's just I'm very aware if there are things that we haven't heard back from everyone yet. We've written out to a lot of bodies within the Assembly. We haven't heard back what their priorities are, but it's just in case there are things that we can move forward quickly. It's whether or not it's reasonable for us to expect things to happen before the summer recess. Really.
I mean, ultimately we're here to support the Assembly, and if it requires something to be done in a particular time, we'll get it done.
We also have the legacy reports that we've looked at what people want this committee to do. There's a lot. One of them, for instance, is something perhaps not for your answer today, but it might be something if the committee does take it forward. One of the recommendations or one of the thoughts was that a private member's bill that the sponsor could potentially, it's not fixed in stone, could potentially attend the committee who is doing, looking at that particular bill in an ex officio, which technically then would mean that they would be getting legal advice. That's something maybe to have, if you guys could have a think about that. It's not something that we have decided upon yet, and we don't know whether or not we would take that forward, but that's the sort of complexities that blows my mind on this, because there's certain aspects where, as you say, individuals are not entitled to receive services, but if that was to come forward, it changes that dynamic.
It does, but as I'm sure the members are aware, different parliaments have different rules on attendance and participation by members at committees, by members of that legislature who are not members of the committee. So, I mean, I don't think there would be a legal impediment to changing that. It would just be for the committee to agree a policy.
Has anyone else any other questions for Jonathan? Jonathan, can I thank you very much. I know that you don't get pulled into committees to give evidence very often, but I find that extraordinarily useful.
Change that.
Sorry?
To change that, Chair?
Absolutely. I think that the more that people know how the processes work appropriately and legally, the better. But that has been extraordinarily useful, and I know we will see you many times. So thank you very much.
Thank you very much, Chair, and I'm sorry about the little snag with the technology.
Technology, gotta love it. Yes, thank you very much.
Thank you.
Members, we also have Ray McCaffrey, who's here today, who's a research officer with the Assembly and Research Information Services. And Ray's going to outline for us today the role of RAISE and the support that it can provide to this committee. Ray, you're very welcome to the meeting. As you've heard, we've one person online at the moment. I will check in if they have any questions when it comes to that point. Ray, over to you.
Thank you, Chair. I'll just get myself out of here. I'm conscious that most members may have already heard from a researcher, so I will try and keep this brief before I move on to the main presentation. So basically the Research and Information Service aims to meet the information needs of members of the Assembly, their staff and the wider Secretariat. The service employs subject specialists and library professionals to provide research and information support across the range of Assembly business areas. And we do this in an impartial, objective, timely and non-partisan manner. We provide a confidential service for member queries, but otherwise we share and publish much of our research in the interest of openness and transparency. So what do we actually provide? Well, we provide in-depth analytical briefing papers on policy, legislation and public finance, which are relevant to Assembly business, including areas within the Assembly's legislative competence and some other areas. Such briefings may be delivered both in writing and also as an oral presentation. We also produce bill papers which address executive and non-executive legislative proposals. These papers provide an analysis of the bill, including some background information, an overview of proposed clauses, a review of the costings provided in the bills accompanying EFM, and potential issues arising from the bill that might merit further consideration. A key part of our service is delivering statistical services. These address all aspects relating to empirical information, including technical advice, interpretation and analysis. We provide a statistical overview of each Northern Ireland constituency in the constituency dashboard, which I know members find particularly useful. Our geographic information systems provide mapping services, and these offer a really brilliant sort of visualisation of a number of issues. They also analyse and interpret data, and it really helps to understand sort of the geographical relationships and patterns and trends, including on a constituency basis. We also provide proactive research articles, and you'll find these on our research blog called Research Matters. These sort of provide shorter topical articles in a more accessible format, sort of more journalistic style, if you will. Primarily for MLAs and their support staff, but of course they're also available to a wider audience. We also provide workshops and seminars on various themes that aim to increase understanding and awareness amongst MLAs and their staff, committees, as well as the wider Secretariat. So in terms of the library, what does the library provide? And I know members, I'm sure, are familiar with the great work the library does. It provides extensive collections of official publications, hard copy and electronic resources to support the work of the Assembly in subject areas, well, really all government politics, public administration, parliamentary procedure, law and Northern Ireland history. And again, it also covers the subject remits of the Assembly's committees and executive departments. I'm sure you'll have seen the information packs that the library produces to support plenary debates on private members' motions, private members' bills, and some committee motions. And these really contain sort of carefully selected resources to inform the debates. They're made available electronically and via email to all MLAs. Or email notification, usually 2 Fridays before the debate in question takes place. Electronic versions are available on SharePoint, and hard copies can be requested from the library. Members, their staff and Secretariat staff are core users of the library. Academics and individual members of the public can visit the library by appointment, and members and their staff are encouraged to attend library awareness sessions, which provide a really comprehensive introduction to RAISE services and resources. Just briefly on knowledge exchange, we partner with academia and other academic institutions under the programme of academic engagement. And this knowledge exchange plays a really key role in delivering that programme. And this is including but not limited to the annual knowledge exchange seminar series, which will be, we're aiming to recommence that in 2024. And I know some members will have participated in that and will have even delivered speaking notes. And it's a really fantastic platform to bring together sort of members and academics. And just I do need to make clear that the RAISE doesn't sort of endorse or promote any particular message at these seminars. We're there to collectively facilitate MLA's access and use of academic findings and expertise. And there's really two aims of that. We want to promote evidence-led policy and lawmaking in Northern Ireland, and we also want to nurture an applied research culture in Northern Ireland. And just very briefly, some things we can't help with. So we can't help with personal, business or commercial inquiries corresponding with constituents. We don't discuss research with members of the public. We don't write speeches or articles for members. We don't really have the resources to undertake large-scale primary research either. We don't provide legal advice, obviously, and that is for Jonathan and his colleagues. And we don't, neither do we provide research to all party groups. Chair, that's just a brief overview of what we do. I know members are probably by now familiar with the work of RAISE, but I'm happy to try to answer any questions if members have any.
I'm looking around to see if anybody has any queries. Do you know what, Ray? I find the services that you guys do absolutely invaluable. It helps to make us look like very incredibly smart people that know everything about everything, but you're doing actually the work in the background. I have to say I can't wait until Kez comes back. Anybody that knows me knows my love of infrastructure, buses and roads, and I find in particular a talk about the noise, that you can reduce noise by the type of road surface, was incredible. Yeah, as you do. Yeah, not everybody's cup of tea, but it was mine. Anybody, any other questions about the research services? We will be using you a lot in this committee because the legacy reports, we have an incredible amount of work coming forward, which ties on very nicely. Ray is staying with this committee for our next piece, which is agenda item 6, which is pages 17 to 46 of the meeting pack. And Ray is going to provide the main points covered in his research paper that sets out the key issues under consideration by our procedures committee and other legislators. Ray, if you want to take us through your paper then, it's very good. Thank you.
Thanks, Chair. So research was asked to provide an overview of the key issues that have recently been considered or are still being considered by the procedures committees and other legislatures. And by other legislatures, I'm referring to the House of Commons, Scottish Parliament, Welsh Parliament, or Senate, and Dáil Éireann. I suppose really, in terms of these committees, a lot of them undertake these discrete pieces of work that are very particular to those committees, but there are other issues such as proxy voting that might have wider application to the Assembly. So we'll begin with the House of Commons. In June 2023, the Procedure Committee published its report Correcting the Record, which examined the methods by which ministers and backbench MPs could correct the official record if incorrect communication had been placed on the official record. And I think this was really against the backdrop of some increasing concern over potentially misleading statements made in the House. And sort of added to this was also the way that people are consuming Hansard on mobile devices and sort of expect corrections to be made a lot quicker than perhaps was the case. The Procedure Committee recommended that the clarity of hyperlinks be improved to highlight corrections and that one central corrections page be developed that would incorporate corrections from both MPs and ministers rather than only ministers, as was then the case. And in October 2023, the House endorsed the Committee's recommendations. Turning to the issue of proxy voting, the Procedure Committee had previously recommended that proxy voting be extended to members with a serious or long-term illness or injury. This followed on from the decision of the House to make permanent proxy voting arrangements for childcare arrangements or complications relating to childbirth. So a pilot was undertaken, and the committee reviewed this pilot scheme relating to proxy votes for serious and long-term injury, and found that it had been a success and should be made permanent, and this was then endorsed by the House. And members, the paper sets out the proxy voting scheme published by the Speaker of the House of Commons and the relevant standing orders. And this deals with how members are to apply for proxy votes, including whether they can self-certify or they need to produce medical evidence, varying the application of proxy votings, the length of time they're valid for. And basically, at present, MPs can apply for a proxy vote on the following grounds. So it's childbirth, care of an infant or newly adopted child, complications relating to childbirth, miscarriage or baby loss. And then we have the serious long-term illness or injury subject to the conditions set out in the scheme. And again, there are certain, that's more, maybe more paperwork involved in that, rather than if you're going sort of, for members applying for childbirth, it's self-certification. But if you're going for serious long-term injury or illness, there is a bit slightly perhaps more complicated. And then moving on to somewhat related, the presence of babies and children in the chamber in Westminster Hall. The committee heard contrasting views and noted that current guidance did not in fact permit their presence, but that the Speaker has some discretion in the matter, and therefore the committee was content not to recommend any change to the status quo. Finally, in relation to the House of Commons, there are just a couple of items of correspondence that I thought it was worth highlighting that the committee was dealing with. The first relates to risk-based exclusion of MPs from the parliamentary estate. In circumstances where the police have provided information to the clerk of the House that an MP is subject to serious allegations of violent or sexual assault. In correspondence between the committee and the Leader of the House, the committee expressed concerns that those members excluded on risk-based grounds would still have access to a proxy vote. A motion on the matter was published on the 31st of January 2024, and this motion does include provision for such members to apply for a proxy vote. And the latest information that I have is that no date has been set for a vote on the motion. And finally, just on the Commons, the committee considered correspondence from the Legislation, Justice and Constitution Committee of the Senate, who wrote to them seeking clarification on the status of Welsh and English language versions of statutory instruments being led in both the Senate and the UK Parliament. I think there was some confusion around whether a Welsh language instrument could be led in the Commons, and the Senate had sought clarification in this. It seems that sort of back and forth in the correspondence that there's no real impediment to that, but I think there remains on the part of the Senate committee some confusion, but as it stands, it seems that yes, you can lay a Welsh language statutory instrument in the Commons in circumstances sometimes where SIs need to be led in more than one legislature. Scottish Parliament, the Scottish Parliament Standards, Procedures and Public Appointments Committee has recently addressed two technical issues, those being legislative consent memorandums and parliamentary privilege. It was brought to the committee's attention that in circumstances, and this is slightly technical, but I think it's maybe worth raising, in circumstances where the Scottish Government recommended withholding legislative consent, there exists a gap in standing orders that would permit a debate to take place. Nevertheless, it appears that debates have taken place in such circumstances. And I think the committee, there's concern there that they just want that gap closed in some way. Another issue that has arisen in this context is circumstances where the original legislative consent memorandum did not recommend consent and therefore no consent motion has been lodged. It is unclear whether a supplementary LCM would be required where the bill is amended to include relevant provision, but the Scottish Government still doesn't intend to recommend consent. And the upshot of that is that the conveners group in the Scottish Parliament, which is the chairperson's liaison group, said that it would welcome the committee's consideration of these matters. The committee is considering this matter and is due to give its views before the end of June 2024. The committee discussed a paper on parliamentary privilege at its meeting on the 23rd of January 2023, which set out the context of privilege in the Scottish Parliament and how it differed from that in the UK Parliament. committee agreed to write to individual political parties to gauge their views on the operation of privilege in the Scottish Parliament, but no further information is available at present. So turning again to the issue of proxy voting, following a pilot of proxy voting from January 2023 to December 2023, the committee recommended that proxy voting be made permanent, and subsequent changes to the rules or the standing orders gave effect to the committee's recommendations. And Rule 11.5a, which is in the paper, sets out the process and eligibility criteria for the scheme and is reproduced. The actual scheme is reproduced at Appendix 2 of the paper. And similar to the House of Commons, the eligibility criteria for the scheme extends to the following categories: maternity leave, paternity leave, parental leave, adoption leave, or shared parental leave, complications arising from pregnancy, serious long-term illness or injury, bereavement, or attending to a person who is near the end of their life. And again, the scheme goes into much greater detail about how that actually works in practice. In July 2022, just going back slightly, the committee produced actually an interesting report into future parliamentary procedures and practices. And this came out of the changes, I suppose, enforced on the Parliament as a result of COVID-19. And the report actually sets out how some of the innovations and practices could carry over into the post-pandemic era. And really key to its consideration was the type of institution that the Scottish Parliament would be in 10 years' time, rather than just sort of looking back to what happened during COVID. So, for example, again, you're talking about issues such as hybrid attendance and proxy voting. So while emphasising that in-person participation in parliamentary business should be the normal expectation, the committee concluded that hybrid meetings should continue in order to provide members the opportunity to participate remotely in certain circumstances. The committee believed that committing to continuing hybrid arrangements was consistent with the Parliament's founding principles of accessibility and equal opportunities, and it will allow the Parliament to be more inclusive in the future. And provision for remote participation in chamber and committee meetings is present in standing orders, and this includes allowing members to vote remotely. In terms of the Welsh Parliament, there has been a lot of discussion in recent years around reforming the Senate in terms of increasing the number of members, increasing the number of ministers. So following a report from the Special Purpose Committee on Senate Reform, the Business Committee, which essentially carries out the functions of the Procedure Committee, published a response that focused on 4 particular areas. These were the size of the Welsh Government, number of deputy presiding officers, number of Senate commissioners, and consequences of a member changing their political party. And really, I suppose one of the key recommendations from the committee was to increase the size of the Senate from 60 to 96 members, and the number of ministers from 12 to a maximum of 19. And the Senate Members and Election Bill, currently before the Senate, implements the recommendations of the Special Purpose Committee. On the issue of proxy voting, in March 2020, the National Assembly for Wales, as it was then known, implemented a trial of proxy voting for parental leave. The provisions were extended twice before being due to expire in April 2023. And having reviewed the operation of proxy voting, the Business Committee proposed that proxy voting provisions for parental leave should be made permanent. And this should be extended to include periods in which a member is absent due to long-term illness or injury, carrying responsibilities and bereavement. The Senate agreed the changes on the 29th of March 2023, and the standing orders, again available in the paper, set out the process to be followed. And this is also in addition to the fact that members can participate remotely in proceedings. Although standing orders interestingly make clear that it is the responsibility of the member to ensure that they have access to the remote voting system. I don't know whether perhaps there were some, that's on the back of some technical issues that they experienced. Finally, members Doyle Aaron, Committee on Standing Orders and Doyle Reform, has generally been examining sort of smaller discrete pieces of work, but there are 2 pieces of work that might be of interest to members. These are a proposed amendment to standing orders to allow remote participation in committee meetings in circumstances where the member is present within the parliamentary precincts. That also precluded members from participating in divisions where they are participating remotely, and Standing Order 106(4) subsequently provided for this change. There is currently no provision for proxy voting in the Dáil, as it was found to violate Article 15.11.1 of the Constitution, which provides that all questions in each House shall be determined by a majority of the votes of members present and voting. And this was taken to mean the physical presence of members. The 39th Amendment of the Constitution Remote Parliamentary Voting Bill 2020, currently before the Dáil, will address this issue. It will enable enhanced flexibility for the working of the Houses of the Oireachtas in times of emergency. It will also serve that by enabling remote and proxy voting to allow members who cannot be physically present, either through temporary but enduring incapacitation or by virtue of maternity or paternity provision. So it would essentially amend the Constitution by allowing and giving the Dáil greater flexibility in these matters. Members, that's a broad overview of recent developments in other legislatures. I suppose if there's one sort of unifying theme, it's the continuation of some aspects of those emergency provisions that were adopted in response to COVID-19, namely, the implementation of permanent proxy voting schemes in the Commons, Scottish Parliament and Senate, and what seems likely now a move towards a permanent proxy voting scheme in Dáil Éireann. Happy to try to address any questions that members might have.
There's a few. I think everybody's going to be asking you questions, Ray, but I'll jump in first as chair. Can I just double check, if you come across anywhere, proxy voting, as you say, is something that's coming across all the ledge, and we're a bit behind the game on this one in the Northern Ireland Assembly. But can I just double check, have any of the other legislators considered bringing in proxy voting for committee proceedings? There's a particular reason why I'm asking that, because we have had a response from one of the committees that we've already asked for evidence about this. But has proxy voting been done? Is it just in the chamber, or is it?
As far as I did look at that, I couldn't see anywhere where proxy voting was available for committees. Mm-hmm. It's remote participation, but I couldn't see anything for proxy voting, and it wasn't an issue I looked at because I thought that it might come up. Happy to go away and look at it in further detail, but I didn't come across it, I have to say.
I think my concern, well, it will become clear, but it's in relation to committees that are meeting during recess. Yeah, so that's one of the things. The other thing I wanted to ask you about, is there any evidence that consideration has been given by any other of the legislators to introduce proxy voting for members who are absent on official parliamentary business? So we have business that the Speaker has approved that members can attend. Has there been anything of any of the other legislators that allow proxy voting for those members that are away from the Assembly on those purposes?
Again, Chair, it didn't arise. I suppose the House of Commons, they have in place a pairing arrangement.
Yeah.
I suppose in circumstances like that, I mean, a lot of this is at the Speaker's discretion. It could be that the Speaker, if it's official parliamentary business, that, a proxy vote could be extended. But it's not in standing orders. Yeah. So I don't know how much then leeway the Speaker perhaps has, or discretion.
I know it's something that may come up as the requests come in. I'll go now to members, and to be honest, I'm just going to go round the room, folks. So Militia first, then Robbie, and then over to this side. Yeah.
Just in relation even to that question in the Dáil, and if that's impacting on the Constitution, it's probably require another referendum.
If it amends the Constitution, yes. Now, as the bill is written, it says, it sets out this amends the Article 15, but any amendment to the.
So it's actually regarded as critical in that respect.
Yeah.
That it would be a change to the actual constitution itself. The system that they have there present, they still accept paired voting, isn't that right?
In the Dáil?
In the Dáil.
Yeah, I believe they do. Yeah.
And then just that point about the person having to be there, we'll say in person as such. Well, whilst we're not talking here about proxy voting, but at the moment we're actually hoping, we're waiting anyway on the Minister will say to make a decision in terms of even people remotely engaged in committee being able to sort of vote in that situation. And maybe would it be seen to be important to extend that to proxy voting?
Well, I suppose the point of proxy voting, if a member, is incapacitated or simply cannot be involved in parliamentary proceedings for whatever reason, I think that's where the proxy vote comes into play. And of course, your members might be aware of the sort of mini scandal or crisis that engulfed the Dáil when the electronic voting system was being sort of, members were voting on behalf of other members, and I think this brought this whole issue to the fore, really.
Robbie.
Thank you, Chair, and thank you for your briefing. From my perspective, it's really good to see in each of the legislatures so far the mention of adoption in terms of that parental piece, but there's the omission of foster parents. A start to me. I was just looking at the statistics for Northern Ireland. 89 children were adopted in 2022. However, there are 3,500 children currently in the care system who could and would avail of foster care. And the barriers to encouraging people to become foster families. I'm just wondering, in any of the research that it pick up in any of the other packs from the other legislatures where foster families, foster parents, foster carers were included, even in a discussion to see if it was possible that the adoptive piece could be extended. I don't think it does extend to foster carers and foster parents because they face probably in some instances some more challenging instances because you have the short term, the respite, the emergency placements and stuff. And then the second question then is in around participation for people with a disability. So this is proxy voting and beyond. This is more to do, I suppose, with the provision of hybrid. And we know that those who are unemployed or economically inactive, the disproportionately high levels of people with a disability. So in terms of if we were to consider that this legislature would be a banner and fly the flag for disabled participation, is that something that has bounced out of any of the research?
Probably on both those points, Mr. Butler, no, they didn't. But obviously if this committee decided to address this issue in the wider assembly, there's nothing to prevent other categories being included, just because they haven't been included in the other legislatures. And again, as I made the point, probably some of this is at the Speaker's discretion as well. But as long as it's within the competence of the Assembly, and the Speaker is amenable to it, and the Assembly would endorse it, there's nothing to sort of limit the categories.
Thank you. Thank you. Thank you, Chair.
Leah?
Yes, thanks very much for the presentation. So, a couple of questions. I actually think that point that Robbie made is really important in terms of foster parents as well, because as you said about the blockages and trying to get people signed up to that, and it's just as important as whether you've adopted a child or you're fostering a child. So see in terms of the reference to parental leave, if you can just describe that a wee bit further for me. That's my first question. My second question is around, so again, there was some descriptions around if you're off on long-term illness or injury, but I'm also thinking about, and obviously, hopefully this isn't the case for any members, but in terms of mental illness, and mental illness isn't always necessarily a long-term illness. It can be something that obviously affects someone quite suddenly, and I'm just thinking, would the long-term illness include if, you know what I mean, a member obviously was mentally unwell for it doesn't necessarily need to be a long period of time, but if there was the inclusion of that within that definition. And then my final question was around, you were talking to Kelly around the discretion, some of the discretion that the Speaker would have around giving people sort of leeway for different things. So at the minute, does our Speaker have any discretion in terms of proxy voting? And if this committee does bring forward a proposal to amend the standing orders for proxy voting, how descriptive would we need to be, or how much sort of can you leave to the discretion of the Speaker?
Thank you. I think, firstly, each scheme is different. So when you talk about childcare, each scheme might be slightly different. So, you know, for example, the House of Commons proxy voting scheme. Proxy voting is available to new mothers, new fathers and adoptive parents, or in circumstances where there have been complications relating to childbirth, miscarriage or baby loss. Now, when you move on to duration, the existence of proxy voting in the House of Commons is based on a general expectation of absence from the estate by virtue either of parental responsibilities or the severity of the illness. Members should not apply for or retain a proxy vote if they intend to or become able to attend the estate on a regular basis. For the mother, so in terms of how long it lasts, for the mother or father of a baby, the partner of a person giving birth, or an adoptive parent, a maximum of 1 month may be taken before the due date or adoption date, and a maximum of 6 months after the due date or adoption date. But I mean, that's what the House of Commons have chosen. Mm-hmm. I mean, there's nothing to say that this institution couldn't decide to do something different in terms of time frames. In terms of mental illness, again, you know, the House of Commons, you provide a written statement from a hospital consultant that the member is, for reasons of serious long-term illness or injury, unable to attend divisions or elections in the House. So there's nothing there to preclude mental illness at the same time. In terms of the discretion of the Speaker, how descriptive does this committee need to be? It's probably a policy decision for this committee, probably rather than one that research can answer. Yeah. You know, the Speaker will take advice from officials, etc. But it's probably a policy matter for the committee of how descriptive it wants to be, and then for the wider assembly to endorse that.
No, that's great, Ray. Thank you. And sure, just to finish, because I'm even reluctant to say this out loud, because again, hopefully, you know, none of us are ever in this position, but I'm even thinking of, like, you know, emergencies at home, or, you know, parental emergencies, or, you know, I know there's bereavement there and there's illness, and there, but and again, I don't even like saying it out loud, but just if it's something that we need to explore down the line, because emergencies do happen within our personal lives. So, and if there was an important vote taking place.
And then that you know, you factor that into the time frames that within which members can apply for a proxy vote.
Danny?
Yeah, I agree with everything that's been said. Particularly want to agree with what Robbie was saying just about disability. Certainly during the local government, when I was a councillor during COVID, you know, when we opened up and we had hybrid meetings and effectively proxy voting within local government, it worked very well. And it, you know, enabled people to come to meetings a lot easier, opened up accessibility and made meetings more inclusive. But you know, there was clear benefits there, and I think we should take the benefits that we've learned from COVID and kind of bring them on with us. A couple of questions about it. Well, I'm not entirely sure, reading your presentation and you were delivered there, how it works with independents and people in small parties, maybe where there's only sort of one person, for example. I would assume in the case of proxy voting, it would be somebody in your party that you would nominate to be your proxy. But if you're an independent, or if you're in a party of one, for example, are you able to nominate somebody else from another party to cast your vote for you?
Yes, you can do. There's nothing to stop you. And yes, it's, I mean, possibly not ideal, but I mean, person who's solitary member in the House can go to another member. And obviously, one of the things that I think the House of Commons sets out is the trust that's placed in members around proxy voting, and you know, any sort of abuse of that would become a conduct matter. But it is, you know, if someone's giving you their proxy vote, the level of trust that they're placing in you to exercise that vote is.
Would that be extended even if we were looking at proxy votes in committee? So if there was somebody who was in committee, obviously committees are a lot smaller, you would be able to use that within a committee?
Yes, I mean, if you're following the same logic, there's, you know, if you're the only member of a particular party in a committee, but there should be nothing to prevent you going to another member and asking them to act as your proxy.
I wanted to raise as well, I was particularly happy to see terminal illness referenced there. I think it was in the House of Commons one. I think the wording was caring for somebody in the end stage of life.
Yes, there's a couple of legislatures have that in. Yes, and issues around bereavement as well. And yeah, I thought, was it the Scottish Parliament maybe had end of life care?
I think certainly that's something, if we do take this forward, we absolutely should be considering.
Robbie, you want it back in again?
I'll make it brief, Chair. Thank you very much. It's on Danny's points. I think they're very interesting and worth expanding a wee bit further. One of the points I'd like to make, and then it will be a question, is on the business committee, for instance. We've always had a form of proxy voting because you have one representative of the independents who come in and then are the voice for in establishing the business committee's orders and stuff. In our previous sort of coronavirus piece where we were legislating, had the opportunity to take the vote for individuals, and we applied it here. But the question is that are all of the other assembly chambers and legislatures the same in regard to that when you vote, you carry out the wish of the proxy, or do any of the chambers dictate that if you are voting yea or nay, that the person that holds the vote, you kind of have to look for someone who's voting the same way? Because I noticed in some of the standing orders there, for instance, it's quite explicit. They've picked it out and said the person who votes doesn't have to vote themselves and they have to carry out the wish. Just important to know that is the case, because that could have real serious repercussions if someone was to abuse the vote. So in terms of the standing orders, have they all picked that out, or do any of them differ in their approach?
Sorry, Mr. Butler, just explain it. So
We had this during COVID, where if we carried the proxy for another member, we voted our own way, and we voted what way they instructed us to vote. Yeah. But as Robbie's saying, is there anything that's stated in any of the other legislators that the pairing sort of voting has to happen, that there's no deviation away from that, or is there protection there?
It would need to be picked up in standing orders, is my point, to give instruction and also to give protection. So are they all the same? So basically in all of the legislatures, because I can see in some of the standing orders that I've been able to flick through, it's explicit that the person should convey the vote that the proxy is asked for. But I can understand why there would be a reason why you would want to go down. You'd maybe try and find someone that was going down the lobby that you wanted them to go down. To reduce the risk.
Yes, I would probably need to consider that further. You said the risk of someone voting in a way that their proxy didn't want them to vote. I suppose again, well, like I said about the trust issue, if you abuse that,
Melissa's whispered in the mic. Melissa has whispered in the mic. He wants my proxy. You see, and I just want to make sure I'm protected.
Well, at that, I suppose that would be a conduct matter, and maybe a matter for the Standards Commissioner if someone abused the proxy vote in that. You know, if you'd explicitly promised a member, yes, I will cast your vote in this, but you didn't. I mean, that's a conduct. Becomes a matter for the conduct committee.
Danny?
Can I just to follow up for clarity on that? I think it says in the report that all proxy votes are highlighted within the minutes then of whatever meeting it is that it was a proxy vote, that somebody's vote would be recorded, so you'd be able to see quite clearly.
I don't think you get away with it. Yeah. To be fair. Yeah.
The votes. My problem is, particularly in terms of legislation, when the votes cast, and yes, there's a repercussion, but the safety has to come up front too. In terms of if we were going to develop standing orders, I think they were fine the way that, but it occurred to me that it wouldn't be beyond the realms of someone. on contentious issues in particular. So you don't get to pick the debate that you're sick on or you're not available for. And the other thing is accepting the process. So say for instance you have to develop the standing orders, but it is a contentious piece, and say even if you're not in step with your party, how on earth do you get your vote cast if nobody wants to take it for you? Do you know what I mean? If your vote, how do you, like, I'm in favour, I want to explore this, but I want to also get it right and explore all avenues.
I think, members, this is where we're down into the rabbit hole of what we will be talking about with proxy voting. At our away day, we will. I think proxy has come across as something quite strong. This committee will want to look at. There may be quick wins that we want to bring in, and there may be things that we need to delve into a little bit more. I think that, as you can see from all of the other legislators, parental leave is one that's very common. We may need to get into the minutiae of what is meant by long-term sick leave, the legal aspects and the protection of proxy voting, for members. I've certainly voted different ways for a person who I carried a proxy for than I want. I would have preferred they voted, but that was their vote, and they have to respect what their decision is. But this is something we will go down to. So Ray, I think we will be coming back to. The other thing I just wanted to ask, maybe to wind up this part, is it's very clear that standing orders cannot change anything to do with the Northern Ireland Act. And it might be worthwhile if we might come back to and ask for this information. The Northern Ireland Act is very clear on cross-community voting about members present and how that would actually work with proxy voting. So I think we need to just drill down in what the actual law says, and we can't rewrite the Northern Ireland Act with standing orders, so it might well be that we need to consider there may be times when proxy voting can or can't be used, and we need to know that as well, I think, for our away day.
Well, that's almost like the issue the Doyle.
Yeah.
We might need to consider that. But Ray, I think thank you very much for that. That was thought-provoking and very worthwhile in advance of our away day, because it just shows we might think something's fairly straightforward, but once you start to discuss it and peel back the layers, it's like, whoa, we can make it very difficult. But I think for standing orders, just members to be clear, we need to be as clear and precise as we can be, because these are legal matters, and it's how the House works. The more wide we leave it, then the more abuse it could have, and we don't want to make life difficult, of course, for the Speaker or for the House. But no, thank you very much, Ray. We will be in contact with you, I would imagine, very often. Members, it's normal procedure for committee research papers to be published on the relevant committee web pages once they've been presented to the committee. We've had one today. Can I seek the agreement of members for Procedures Committee research papers to automatically be published once considered by the committee, unless the committee decides otherwise? Agreed. Thank you. Thank you very much, Ray.
Thank you, Chair. Thanks.
Members, I'm going to move on to our forward work programme. Members, as part of the induction plan agreed by the committee at the meeting on the 20th of February, a strategic planning event will take place on Wednesday the 10th of April 2024. Members, a initial list of potential key issues that the committee will wish to consider when deciding on its priorities at the strategic planning event has been provided at pages 51 to 58 of the meeting pack, if you want to take a look at that. The list is in no particular order. So no particular order. I'd be pains to say this. That's just a list of all of the stuff put in one place for us, which is perfect. And it's not exhaustive. It can be added to. It will be supplemented with any of the issues raised in the responses from key stakeholders, and a more detailed paper will be provided before the event. Members, could you start prepare for the strategic planning session over the next few weeks by considering this list and what issues you may wish to propose should be prioritised in the committee work programme. If there are any other issues that you would like to have included on this list, please advise the committee clerks as soon as possible. It may also be very useful to discuss what the priorities for the committee should be with your parties. Letters have, as we know, last week were released to all of the last time we met, were released to to all of the parties through the whips. I would ask you to go to your parties and ask for the updates on that. The deadline for responses is the 29th of March, so it would be very useful for us in advance of our away day, and clerks will kindly remind all those that we have written to. We have had one response back so far that we'll deal with under correspondence. Members, a number of the recommendations in the previous committee's inquiry into private members' bills and its inquiry into the legislative consent motions fall to the Assembly to implement rather than requiring changes to standing orders. I want, if I could, get agreement from yourselves that we write to the Director of Parliamentary Services to request an update on the position regarding the implementation of the relevant recommendations from both reports. Agreed? Thank you. Members, recommendation 4 in the report on the inquiry into legislative consent motions calls for full compliance with Standing Order 42A by executive ministers. Could I seek the agreement of members to write to the executive requesting information on the measures being taken to ensure full compliance? Agreed. Agreed, thank you. Members, recommendation 6 in the report on the inquiry into legislative consent motions concerned procedural enhancements and improved communication between the UK Parliament and the Assembly. The previous committee had written to its corresponding committees in the Commons and the Lords on this issue. It would be helpful to request information on the up-to-date position and any progress that has been made in this regard. So therefore, can I seek the agreement of members to write to the relevant committees on this matter and to request a research paper on what, if any, procedural enhancements or improved communication or transparency between the UK Parliament and Scottish Parliament and the Seanad has been implemented in relation to legislative consent motions since the publication of the inquiry report. I am aware that there's one from the Lords that has been produced. Do we have agreement? Yes, thank you. Agreed. Members, the proposed arrangements to hold the strategic planning session is in the Mount Business Centre in Belfast from 10 a.m. to 1 p.m. on Wednesday the 10th of April, and it's set out at pages 59 and 60 of the meeting pack. Several venues were considered and this was identified as the most suitable of all of those available. Could I seek agreement of the members to hold our strategic planning session at the Mount on the 10th of April 2024?
Agreed.
Agreed, thank you. Members, as I said earlier, in correspondence under agenda item 8, sorry.
Just before you go off the forward work programme, just so I get on record, I'd like us to consider work around all party groups, the rules and regulations and the guidance that's given to chairs in particular. I have some issues. I mean, you sit on most of them, so we have a lot of experience in Dana and yourself. In fact, you're chairing an all-party group on the day that we're having our meeting. So, but I think they've been incredibly useful. But I've also realised some concerns that I have in regard to how we go about them and so I think that's something worthy of.
All party groups, and certainly I'm not ruining it, but all party groups, the rules in all party groups falls to the Committee on Standards and Privileges. So it would need to be raised with that committee. And
then if they have anything for standing orders to bring here.
Yes.
Right, okay.
Something that perhaps we could even talk about on the workday to engage them on that.
Yep.
Okay. Is that okay?
Yep.
Thank you.
So agenda.
Sorry, just to the chair, you see two there, just travel and arrangements. Everyone makes their own way.
What page are you looking at there?
Page 59.
Just to make sure I'm in the right one. So I think it's just to notify members. Members will travel to the session independently.
Yeah.
There is parking at the Mount. There is public transport to it as well.
Then travel costs, that's just the same as coming to the Assembly.
Yes, sorry.
Yeah.
Yes, it is. When we organise this, it's considered an external meeting.
Yeah.
So we'd be to put the costs of it, which include.
Just same as your day coming to the Assembly.
Yeah.
Is that okay?
Thank you.
So we're all in agreement then. We're going to the strategic planning session at the Mount on the 10th of April 2024. Then agenda item 8, correspondence. So you'll see correspond page 63 and 64 of your pack. We've received, the Windsor Framework Democratic Scrutiny Committee has replied to the letter from the committee seeking views and suggestions on priority areas of work to inform its discussion at the strategic planning session. The response highlights that while the committee has been established as a standing committee under the Windsor Framework Democratic Scrutiny Regulations 2024, it is not provided for in standing orders. It is therefore asked the committee to consider taking forward the drafting of a standing order to address this matter. It is also asked the committee to consider undertaking exploratory work to identify options that would provide in standing orders for substitute members of, they're calling themselves the DSC committee. To be honest, we're all Democratic Scrutiny committees, but for substitute members.
Or not. There's the problem. Can't get deliveries.
Well, substitute members for their committee, and rules on substitution and proxy voting, given it is likely that it will be required to meet during periods of recess and perhaps more regularly than once a week. So that's why I was talking to Ray about that earlier, because we are aware that this has come forward, and that's why I was asking the questions about proxy voting for committees. Could I ask then for members for these issues to be added to the list of potential priorities for consideration at the strategic planning session?
Great.
Thank you. And as other things come forward, clerks will see those responses coming in, and we'll try to gather that to our list. Then finally, moving on, not finally, but getting close to the end, folks, the agenda item 9, Chairperson's Business. Just to let you know that, as was talked about at the last meeting, we have written to the Speaker's office for a meeting just to discuss the matters that the Speaker may wish us to take through, or does wish us to take through this committee. But the other thing I want to check with you all is it would be very helpful to set up a WhatsApp group of committee members so that members can be contacted at short notice if necessary. To ask each of you, are you content, and for those who are not in the room, we'll check with them as well, if you're content to be included in a committee WhatsApp group, another one, I know you're probably saying, and if you're content with that, we'll make sure that we have all your details. Are members content for that?
That.
Yeah. Hopefully I'll not put messages into the wrong one. No, I promise I won't.
Information would be mailed out as well, so it would be for a sort of short term.
Yeah.
This would really be for emergency stuff.
No, it's just
room changes and
contact room changes, yeah, our extra meetings, or things like, for example, if somebody's coming in remotely, they can tell us remotely that they would like to ask a question.
Yes.
Because it's difficult.
I'm nearly up to 40 WhatsApp groups, so I need just to get up to round it off.
Members, we're on to the any other business section of our meeting. Does anyone have any other business that you would like to raise? No, thank you very much. So the date, time and place of our next meeting, and that will be the strategic planning event, which will take place on Wednesday the 10th of April 2024, and the next meeting of our committee is currently scheduled to take place on Wednesday the 17th of April at 10 a.m. in this room 21 Parliament Buildings. So members, just to remind you, we're about to go out of session, but when we turn off, the feed may be live for a while, and I advise members that the meeting is now adjourned.
Committee Room 21. Sound. Committee Room 21. Sound.